Good morning, everyone. Thank you for tuning in to watch our webinar on COVID-19 and international arbitration, what to expect in the near future. It is my pleasure to introduce our guests, Professor Stefan Kröll, Professor Marike Paulsson, Professor Cláudio Finkelstein, and young talent Camila Simão. On behalf of the CAMSA-CBC, we thank you in advance for sharing your thoughts and predictions regarding the impact of the COVID-19 pandemic, specifically in the field of international arbitration. We at the CAMSA-CBC have been working remotely for 45 days. It has not been easy, but we stand strong and continue to perform our activities by maintaining the Secretariat fully operational with the continued support of our IT team. We believe that we can contribute more as an arbitral institution by not obstructing the 300 ongoing arbitration cases that we administer, which currently amount to almost $6 billion. So this means working together with lawyers, parties, arbitrators, everyone in a safe manner, while also minimizing any potential financial harm. The president of the CAMSA-CBC has issued an administrative resolution 39, then followed by Administrative Resolution 40, which all deal with the new structure of the CAMSA-CBC during this time of pandemic. Our cases are being carried out electronically. So for over 300 ongoing cases, we had only minor setbacks, so only a few cases which were suspended either by the arbitral tribunal, by request of the parties, or by the CAMSA-CBC because of inappropriate notification of the respondents. And we have 16 lawyers, the 16 young professionals, which are our case managers, and they are all working full-time as usual, and they're answering all questions and anything by the arbitrators and the parties by phone and email. We also keep getting new arbitration cases, new mediation cases. They are, in comparison to last year, we have about the same amount of cases. So we don't see yet an impact, neither for more or less in the amount of cases. All of our hearings are being carried out through Microsoft Teams or any other preferred platform. We initially chose Microsoft Teams, especially with concerns regarding cybersecurity in light of the confidentiality of the proceedings. But then by request by some of the parties, we have also included the option to carry some of them in other platforms such as Zoom. We have also included in the administrative resolution some technical and general recommendations regarding virtual hearings. And we are also working, like some of the other international institutions, on a full guide for virtual hearings. We are also working on new improvements for mediation. So mediation is, in terms of being carried out electronically, different than arbitration, but it can also be done, and we are working on that, especially regarding the needs of the mediation, which are different than those of the arbitration. And if there is a time in which arbitration can be a powerful way to resolve disputes, I believe that it is right now. But in spite of all of that, I mean, in addition to all of that, we cannot lose sight of what is important at the moment, and that is our mission as an arbitral institution, to maintain efficiency and to continue standing by our own ethics and transparency, working for diversity and all of the things that we usually are concerned about. And some even started a discussion about environmental contribution. So if you take into account that the past 45 days has been completely electronically, we, as an institution, didn't send over 4,000 packages and mails, which can mean a significant reduce in both paper and pollution. There's even talks about the institutional role as a social contributor. So we have donated to the hospital of the São Paulo, University of São Paulo School of Medicine, an amount of money that was reserved for sponsorship of a Congress which would be carried out later this year, the CBAR Congress, but it's not going to happen. So we decided to give back to the community, which needs in times like this. Our institutional work has also been carried out electronically. This discussion right here, this webinar, and also all other webinars are proof of that. So we are also very thankful for everyone working in order for this to happen. And in sum, all of these tools are something we've been investing on for years and years now. And even though we are now facing an extremely challenging time, we hope to learn from this experience and continue to evolve as an arbitration institution and as part of the arbitration community. Some say that the arbitration is as good as the arbitrator. And now with this role of the institutions in leading change and in leading different approaches, I can say that the arbitration institution is also as good as its users. So it's arbitrators, it's lawyers acting in its cases. But enough for me. Let's hear from them, the experts, what we can expect in the near future. So please take it away, Camila.
Thank you very much, Luíza. I just saw that Eleonora has also welcomed us to the database of CCBC, Camp CCBC. Thank you all for hosting us. Thank you, Stefan. Thank you, Marike, for dedicating some of your precious time to the Brazilian audience. I guess we have people from other places as this platform allows for I mean, there's got to be some advantage of all that we're living through. So if we have people from overseas, welcome to Kansas CBC Brazil's platform and database. Thank you, Camila, for together with the Brazilian Arbitration Students Association. Camila is the sitting president of the association. We were discussing what's to expect in the near future. I mean, we're facing new realities, new normals, if so to speak. And we basically wanted to hear from people pretty much involved in the international business of arbitration and international business of international law per se, what's to expect. So thank you again, Stefan, for agreeing to be here. Thank you, Marike, for agreeing to make some of your precious time available to us. I now pass the floor to Camila to introduce the speakers.
Good morning, everyone. As you can see from the screen, my name is Camila Simão. I'm a lawyer at Finkelstein Advogados, and I'll be moderating this panel together with Professor Cláudio. Before I start, I would like to also thank CBC, not just for hosting our webinar today, but also for their work in promoting all their incredible webinars and in continuing to administer all of their cases. And before I introduce the speakers, I would just like to explain how we will structure the webinar today. So our idea is to focus first on substantive issues. Each of our speakers will have around 10 minutes to discuss what are the possible disputes that might arise because of the COVID-19, both in commercial and in investment arbitration. And then we'll move on to the impacts that the COVID-19 and that the ensuing social isolation might have on the procedure aspects of arbitration. And if we're good with time management, each speaker should have around 10 minutes for these issues as well. We will save all questions for the end. So if you have any questions during the presentations, and we hope that you do, please write them in the chat. And by the end of the presentations, Cláudio and myself, we will try to pose all of the questions or most of the questions to the speakers. And I think with that, I can introduce our first speaker, who is Professor Stefan Kröll. He's a professor of international dispute resolution at the Bucerius Law School in Hamburg. He also acts as an independent arbitrator. And as most of you know, he is one of the directors of the Vismut, and he has extensive experience and knowledge with international arbitration and international law. And I think with that, Stefan, you have the floor, or the virtual part.
Thank you very much, Camila, for introducing me. Thank you to the organizers for inviting me to Iguazu. Yeah, I really appreciate that. Unfortunately, it's only a virtual invitation, so I'm not sitting there, but I thought there was a nice reminder of my short stay in Brazil. When we discuss between the two speakers what we should say about COVID-19 and international arbitration, we decided it would perhaps be good to start with the type of disputes that we expect to come. And I assume that in the near or not so near future, we will see a number of disputes coming out of COVID-19, both in commercial arbitration and investment arbitration. And why do we go to the disputes a little bit? Because we think it will also influence arbitration, or at least it should influence arbitration in a completely rational world. So in the first part, we'll address that. Then we will, in the second part, address the organization of virtual arbitrations. And again, split that up between the two of us. I'm dealing more with the legal admissibility, while Marike is covering questions of organization of this hearing. There are a number of other issues we were coming up with when we looked into our crystal ball and gazed what would be the future. We are not addressing a potential problem which also will increase in the future, that is arbitrating with insolvent parties, because we are sure that there will a number of parties which will not survive the present crisis. And we will not, unless there are certain questions, directly address the question how that will influence the future drafting of contracts, in particular in relation to arbitration, or the future drafting of arbitration rules, institutional rules. So let me come to the question of what type of disputes we have. When you look at the COVID-19, the factual consequences, apart from the health effect it has on a number of people, often key personnel in contracts, the main issue are the measures imposed by the states to slow down the spread of the virus and to protect health and safety of its citizens. And you have different measures in different countries. And if I refer to measures, please take into account, I'm from Germany. So my experience is really limited to Germany, what measures we have. So most of my experience, most of my examples will come from Germany. You have a number of lockdowns, you have export-import bans, in particular of medical equipment, which is considered to be important. You have travel restrictions. And he has also a number of measures directly interfering with contracts. For example, in Germany, the government immediately made a law which put a memorandum on lease contracts, for example. There was an exclusion of the right to terminate the contract for arrears in lease, and you're no longer obliged to pay your lease, your rent, for the next 4 months until you can basically generate revenues again as a company. Most of these measures also affect in practice the ability to perform the contract. The question which then arises, and which will in our view lead to increasing a number of arbitrations or at least disputes, is do these measures also affect the obligation to perform, the legal obligation to perform? And here the easy one is, what are the legal consequences of that? The easy one is if you have measures by the state which directly include the legal consequences on a particular contract. I mentioned the lease example. The more difficult one is how do import or export bans, for example, or lockdown of companies, suppliers, which affect the factual ability to perform a contract, what will be the legal consequence of that? And again, we are into the perennial problem of the scope of the principle of sanctity of contracts, or pacta sunt servanda. That problem has also arisen in a number of other crises. In the financial crisis, we had issues like that. Whenever you have sanctions against a particular country resulting in export bans, import bans, you have questions concerning the principle of sanctity of contract. The difference here is just the size. So events like the COVID-19 pandemic have, at least in our lifetime, not occurred. And the second difference is there is an uncertainty as to the effects. So a lot of the governments are just basically adopting measures without really knowing sufficient about the virus, balancing different interests and risks, and running the risk of imposing too many or too little measures. And when you look at the contractual problems there, you have two different types of contracts. You have certain types, in particular long-term agreements, which have already a provision in there for unforeseen circumstances. And then you have the other type of contracts, very often one-off contract, sales agreements, whatever, without such a contractual regulation. Let me first turn to the contracts which have this type of contractual regulation. Most of them have then a force majeure or even a hardship clause. And you see that, for example, the ICC has, in the light of the COVID, really pushed its new clauses. You have in 2020, you have the new force majeure and the new hardship clause out. So what happens in these type of disputes? What is required? In principle, it's a fairly easy task, which you also have in a lot of other contracts, are the requirements for the application met? Again, talking about the German experience, over the last years, we had numerous energy arbitrations where the whole issue was, have the trigger events of these hardship clauses been met? Has there been a change of the market, whatever? Again, here the problem may be a little bit more difficult because in the energy market, you had a lot of data, you had issues, it was a smaller market. Now we are dealing with a global pandemic, which makes it a little bit more difficult. The second question which arises there is, what happens if the requirement or the trigger event of these application of these contractual clauses have not been met? Is there still room there for the general theories such as frustration, imprévision, or the German Wegfall der Geschäftsgrundlage? And second, you have the legal consequences of these clauses. The force majeure clause, again, is fairly easy. It just excuses performance, excludes damages, and may give the party the right to terminate the contract. The hardship clause, by contrast, usually requires the parties first to try to renegotiate the contract and then may later give the judge or the arbitrator the power to adapt the contract, really changing the contract. Again, the energy arbitration cases have been comparatively easy because you knew what you were adapting to, because the market had changed in a certain way and there were certain parameters. Adapting a contract now, a long-term contract in a situation which is kind of moving target, may be very difficult. And when you come to the other types of contract where you don't have a provision for contractual adaptation in the change of circumstances, you have the legal theories under the law applicable to the contract. And under these legal theories, you have a considerable divergence between the various laws. You have on the one hand, the common law, which really has a very strong emphasis on the sanctity of contract principle, but there is no obligation to adapt the contract. By contrast, in a lot of civil law countries, again, I take Germany as an example, you have special theories which are much broader than the theory of frustration and require the parties to renegotiate the contract, and if they cannot reach an agreement, give the arbitrator the power to adapt the contract. In these cases then, the question arises, what is allowed under these national laws? And it may also depend on which is the governing law of the contract. And last but not least, you may have a number of questions which arise if you have submitted the contract, for example, to the law of Germany in a case between a German and Brazilian company, and then the Brazilian government imposes certain restrictions. are these restrictions to be considered by the arbitrator to be overriding mandatory provisions which apply and affect the legal rights of the parties, though the contract is in principle governed by German law? Why are we referring to all that? Because we think it should influence the arbitration, at least the arbitration which have not been started yet. First of all, it should influence your selection of counsel. We are dealing here with very vague concepts which require very convincing people trying to convince the arbitrators to fall on one side, on your side of a particular case, because it's never a clear-cut case. And it depends very much on how you convince the arbitrator that we have now an exceptional case where contractual obligation should no longer be performed as have been agreed upon. But more important is that you select the arbitrators accordingly. Why? If you, for example, have a clause which provides for contract adaptation in the end, you want to make sure that you have someone who really understands the particular area there, who understands what happens if he amends or she amends the contract in a particular way, what the outcome will be. And it's even more important if you have no clauses in the contract, but you have to rely on the legal concepts. If you want to adapt a contract, if you want to terminate a contract, it's probably better to select someone who comes from a civil law jurisdiction, which has been brought up in a legal system which is familiar with these type of remedies. By contrast, if you want the other party to perform the contract as it has been agreed, you better go for someone who has been brought up in a common law system and who believes much stronger in the principle of sanctity of contract. So these were in my view, some of the issues which may arise from the COVID-19 concerning substantive contract and which should, in my view, affect arbitration in these two particular ways in commercial arbitration. But I was just talking about commercial arbitration. The next issue we have is investment arbitration, because a lot of the measures have been implemented by states. And the question then is, are they correct or are they depriving me of my investment? And I will now turn over to Marike to deal with that questions and to deal with the questions or issues. Maybe there is a different way of addressing that than arbitration. Marike.
Thank you very much. Just before that, I know Marike does not need introduction, but maybe some people don't know. So Marike is the senior advisor of the Albright Stonebridge Group. Has extensive experience in public international law, international arbitration, human rights, and cross-border litigation. Marike is also the former director of the University of Miami School of Law International Arbitration Institute and professor of international law. Marike is also the vice president of the vice president for North America of the Global Legal Institute for Peace and Conflict Resolution. In addition to that, she's the author of possibly the best book in the New York Convention. So please, Marike, welcome to the Kansas CBC database.
Thank you, Claudio. Actually, I have a new title, and I think it's my #1 title since COVID, because we've been on a lockdown for 2 months, and I'm now officially, I think, a qualified year 3 grade 2 teacher. I've been teaching my 8-year-old for 2 months, and I have now learned that it's a lot harder than teaching law. So we're all ready for a glass of wine of sorts. So I'm going to jump to investor-state arbitration with one big disclaimer. We have experience in international law and international arbitration, but I think that if there's one thing that we will all agree on, except for President Trump, is that everybody knows that if there's one thing we know is that we know nothing. So the only thing we do every day is speculate. And it will be maybe 10 or 20 or 30 years from now that others will study this pandemic in the history books, that they will have all the data and they know exactly what happened, but we don't. So everything we say, please bear in mind that I will never say that I'm an expert in sort of post-pandemic claims. So moving a bit to potential issues that are arising between investors and states. As you all know, some of you have been on lockdown for longer, some of you for 3 weeks. As Stefan points out, if you compare the lockdown in Europe to the Gulf region, to India, to the US, it's entirely inconsistent. So the experience is different, but what we can all see is we are now forced to depend on our own countries, and international trade, international shipping, traveling, it's all come to an abrupt halt. And obviously that is going to lead to claims. Now, one thing that we all need to remember is that these claims are not going to be binary. It is not a claim that an investor could have against a government for expropriation, or the government did something that constitutes a denial of justice against that investor. We have international companies who have investments in I don't know how many countries, who supply to others, and those companies again supply to others. And they are all feeling the impact of governance choices in each of those countries. So there's no uniform governance across the globe. And again, this is where we all learn that sovereignty is the counterpart to an international arena. It is up to all state governments to decide how they're going to handle this pandemic. So this is going to be a very complex legal problem. What you will see is that what Stefan also mentioned, one thing that we now read everywhere by all the newsletters and the reporting and law firms and experts is force majeure, unforeseen circumstances. If there's one thing we know, is that there is not a single law in the world in our generation that has some provision that deals with force majeure that relates to a pandemic of this magnitude and the consequential decisions that have been made by states. The counterpart of that force majeure is good faith. I think we can all agree that whatever governments are doing, they're trying to do the best. For the American participants, I'm so sorry, I'm not sure if that also applies to the US government, but I would say in the rest of the world, everybody is trying to do what they can. So we have no roadmap. We have a crystal ball, we need magic, and we need our wand to figure out what the future is going to look like. Most of us on this webinar, we're lawyers, right? So we think, what claims could follow? What are the provisions in the contract? What are the legal principles in a bilateral investment treaty? Lawyers in the US are already predicting these could be the claims. It could go to this court, we're moving litigation to arbitration, et cetera, et cetera. I don't think this works. We're tailoring to investors, we're tailoring to governments. What do they want? Now, full disclosure, I know I don't work for a law firm. I work with people who are experts in commercial diplomacy. So we tend to be the facilitators for disputes between investors and states. And what's the first answer? What do investors want? Stefan already said it. Nobody wants to go bankrupt. Investors want to keep everything alive. They want to keep things going. To get damages after the end of this is probably the last thing that any investor would want. So some international lawyers have already creatively thought about, what could the solutions be? So one is, let's not look at the current laws, but let's work to create a new law set of legal principles that can be used only for disputes and claims that follow from the pandemic. Now, we are thinking about international law. We're not just thinking in the domestic territory, because then we get to sovereignty. So that is not for us to resolve. That again depends on the executive branch, the legislator, and how the judiciary will apply it. But in the international arena, we could say, let's create a treaty. We have the Algiers Accords. Let's create a treaty for COVID. That could be a solution. We can say, let's have a tribunal. Let's have one tribunal that will deal with all these claims. And as many of you know, the Netherlands is the home of, and especially The Hague, of many, many tribunals following wars. We have also the Iran-US Claims Tribunal. But here is my issue. Let's just go to the present. We have the Working Group 3, where UNCITRAL member states are coming together to revisit the concept of investor-state dispute settlement. They're looking at ISDS reforms. There are those who have proposed a multilateral investment court. There are those who have proposed an appellate mechanism. I've been involved in this process, and the only thing I know is that there is one thing: there will never be consensus. And this is complex, the multilateral investment court and ISDS reforms, but not nearly as complex as the whole idea of UN member states, all of them having to draft and reach consensus on a treaty that would be applicable for COVID disputes. Would we have a working group? Would this be a working group of UNCITRAL? Would this be a working group of the United Nations? Would we have one treaty? Would we have reservations? Would we have declarations? How do we appoint the adjudicators to that tribunal? So again, we're going to get the issues of sovereignty and the problem that we probably will agree to disagree. So the other option is, are we just going to rely on current BITs? I am quite skeptical. I just don't think that's going to work. But one thing, imagine you're the arbitrator and you get a claim of an investor because that investor has incurred massive amount of damages because of the lockdown. And maybe that investor, whether it's on a new treaty or current legal, international legal instruments, has substantive arguments. Let me just go back to Europe. Let me go back to Germany and to the Netherlands and to the EU. After Achmea, where the tribunal said to a certain extent that intra-EU BITs violate European law, there were quite a couple of tribunals who were not willing to go there. So it's almost like self-fulfilling prophecy. So as a tribunal, if you get a claim that follows this pandemic, would you award damages? Or on the basis of good faith, would you not award damages? Because let's get to the present. Most governments have decided to go on a full lockdown, not entirely knowing if this is going to work. I mean, is there herd immunity? When are we going to have a vaccine? Nobody knows anything. But we can see some overall common denominator that most governments have locked down the country because no government wants to create a situation that a doctor has to choose between two patients. It's the human factor that dominates the media. So if we see that, and if we know that this is why governments make certain choices, even after the fact, and in hindsight, it might not make sense for whatever reason, find the 3 arbitrators who are willing to set good faith aside, and on the basis of force majeure, and if ever that leads to denial of justice or anything else, say, okay, we're going to award you millions or billions in damages. I think that's going to be very difficult. We also need to understand in the current climate, and this is only going to get worse, is that ISDS has a bad name. We have an anti-investor sentiment. States want to change their BITs. We have civil societies. It was mentioned already before, investors have to focus on environmental aspects. Third parties need to be involved. So that tide is working against investors. I don't think investors are on the right side of the whole story when they're going to file claims against governments when governments are trying to save people. So the traditional current adjudication path, whether it's national or international, will not work. That would be my prediction. And then obviously also the aspect that investors don't want damages, they want to keep their investments going. So what I would propose is something else, which is mediation and commercial diplomacy. This is an amicable way of preventing and resolving disputes. Culturally, in many more countries, this is more suitable. And I would say we have to look at that at 2 points in the timeline. One is right now. Right now, we need to make sure that there are facilitators like commercial diplomacy experts, mediation experts, negotiation experts, who facilitate discussions between governments, either a bloc, and investors, or a body of investors, to discuss what is going on right now and what the consequences would be for current international trade and contracts between investors and governments, and what they can do right now to prevent any disputes and to save as many investments as possible. And then obviously after the pandemic, which is hard to even talk about because nobody knows what the future is going to look like. When that moment comes that everybody can just sit down and grasp what happened, I think that the lawyers need to step back a little bit and not engage in some claim tsunami, but let the states and the investors sit down together and maybe opt for mediation with the newly signed Singapore Convention on Mediation, or commercial diplomacy. So those are my non-expert takeaways on the future of disputes between investors and states. But as I say, I don't have a crystal ball that works, so we'll just have to be as creative as possible with an eye towards good faith.
If I can comment on that a little bit, I completely agree with Marike concerning the measures taken to prevent the spread of the virus and for health and safety consideration. I think it might be a little bit different if we now come to the post-pandemic measures, where you have, again, based on the German discussion, where you have discussions on how do we help companies and how do we support companies which have been hit by the pandemic, where there is no real issue of health and safety involved anymore, but where there is economic survival the main issue. And I think when I look at the German discussion, there are a lot of things which go into the discussion which are political questions which have nothing to do with the pure economic survival. Question is it justified, or is that company worth that it's being supported by the government? And I think these measures will, to some extent, be used by some government to get rid of some unwanted investors or basically restructure the market. And I think this is the only area where, in my view, as an investor, you might have a chance of getting sympathy, at least from certain circles, approaching the government. All other ones, it would be a very uphill battle, just accusing the government that they made a wrong judgment call in an area where you have no certainty whatsoever. They were my comments on that one. We would now move to virtual arbitration unless our moderators have something else they want us to do. No comment? Okay. Then we move to the virtual hearings. And again, I'm primarily talking about commercial arbitration. It is clear to everybody that the normal way of arbitrating is seriously affected by the various measures taken by the states for health and safety considerations, but in particular also for travel restrictions. And there are a number of issues which you have to address. Most of the institutions have already addressed the problem of submission of briefs and documents, have been very flexible, much more flexible than many of the state courts in adopting to the new situation. But the main issue is what happens with the hearings. It may be difficult to come together physically, or it may even be completely impossible to come together at a single location. And again, I think we have two different types of questions which arise in that context. The first one is if both parties or if all parties agree that they want a virtual hearing. Then the agreement of the parties basically is the prime guidance for the arbitral tribunal, which nevertheless has to ensure under most jurisdictions that the right to be heard is protected and that there are fair proceedings. But most of the time, if the parties agree on a virtual hearing, it's very difficult to say later on that the proceedings haven't been fair. There may be issues of cybersecurity and data protection. Again, they do not differ from other arbitrations too much, which are conducted today and where you also rely heavily already on email transmission or whatever. You will have problems, or you'll have probably a different procedure order 1 or an amended procedure order 1, which regulate technical requirements, whatever lockdown, may regulate the breakdown of technology, regulate the taking of evidence. And you have numerous guidelines by institutions already or law firms concerning the examination of witness and experts. Again, I think with that guidance, you should be able to conduct a proper virtual arbitration. And Marike will go into greater detail there. So I'm now looking at the cases where you have one party objecting for whatever reason. And it may very often be the respondent who just wants to delay the proceedings and knows that a hearing cannot be held in person and it will postpone payment of the amount due for an indefinite period. The problem is that on the other hand, we have this famous saying by Lord Justice Denning, justice delayed is justice denied. And in particular in situations like the present one, where you have a lot of companies having problems with their cash flow, it's a serious issue. So what can an arbitrator do? In principle, the arbitrators have large discretion what they can do. Under most institutional rules and also under most laws, the arbitrators have an obligation to manage the procedure in a way that it's efficient and effective, and also that the claimant is not losing its right of effective legal protection. The problem is some of the rules, however, can contain provisions which may lead to procedural issues. And you can group, in my view, the various institutional rules into three categories. You have the first category, like into which I would put the LCIA rule, for example, which have an express provision allowing the tribunal to conduct hearings online, virtually. Article 19.2 of the LCIA rule states, and I quote now, as to form, a hearing may take place by video or telephone conference or in person, or a combination of all three. That is the first group. That's fairly easy. There's no problem with any procedural questions. Then we have the second group, where I would put the CAMP-CCVC in, where you have Article 7.8 of the CAMP-CCVC arbitration rules, which says it's for the tribunal to adopt the necessary and convenient measures for the appropriate conduct of the proceedings, observing the right to fully defend oneself and the right to dispute the allegation of the other party, as well as the equal treatment of the parties. There is no exclusion of any virtual hearing, and it's probably covered by the discretion of the tribunal. But then you have the ICC, which has in Article 25 of their rules, they have a provision which says establishment of the fact. And they said, after studying submissions of the parties and all documents relied upon, the arbitral tribunal shall hear the parties together in person if any of them so requests. Or failing such a request, it may its own motion decide to hear them. So there's an obligation to hear them in person. And that may create problems whether in-person hearing is possible if it's a virtual hearing. The ICC has seen the problem, has issued a guidance note on the possible measures aimed at mitigating the effect of the COVID-19 pandemic in this month, and where they said, okay, it could be interpreted. But they've been very cautious there because they know it's a difficult question and they cannot have a guiding or cannot have a definite position on that. They say the language can be construed as referring to parties having opportunities for live adversarial exchange and not to preclude a hearing taking place in person. But can be construed does not mean should be construed, must be construed. So there is an issue there with the procedure. But then if you go a step further, even if the rules allow that, you have the applicable arbitration laws. And the applicable arbitration laws very often give the parties or give each party a right to a hearing. And then the question arises, what happens if one party says, I want to have a hearing in person, and the other party says that a hearing means you have to be heard, being present, and if you're only virtually present, that is sufficient. So that is where the real problem arises, in my view. If you have a party obstructing, and there are a number of ways in which a party may be able later on to claim that the virtual hearing has not been efficient and it could not properly present its case. Take the example of a witness sitting in a location where you have hardly any internet connection. Some of you may have participated in the virtual viz and may have suffered from problems of bad internet connection with the bespoke system. If you're not using a system which has little requirements, you may run into problems, and you may have seen in the virtual viz that it makes a considerable difference whether you see someone directly in front of you or whether you see someone through a bad image on a computer. So why should someone, a respondent who is not willing for the arbitration to take place virtually, why should they cooperate in these ways? And how can you prove that it was the respondent later on who basically prevented the witness from being heard, interfered with the internet connection or whatever? So there are a number of problems there which may give rise to difficult legal questions. And now I'm not only looking into the crystal ball, I'm just expressing an opinion, though you should normally not do that as a lawyer or as an arbitrator, because they're then not hired by both sides or only by one side. In my view, I think it should hold. If you have agreed on a hearing and the tribunal has done the utmost it can do to have a virtual hearing and there is no major interference there, I think it covers the right to be heard, and it should also hold under the Untitled model law. Don't hire me for that, and I hope that Chatham House rules apply here. Thank you. Marike.
Well, so first of all, I love your reference to Chatham House rules. We were at an Untitled webinar last week for the Working Group 3, and the link was on the website, as many of you know. And one state delegate said, everything I'm going to say, Chatham House rules are going to apply. And that, I thought that was incredibly entertaining, because that's just not how the virtual world works. So I guess I'm the pessimist when it comes to technology. Maybe I'm old school law professor and I still like a blackboard with chalk, and I find this all very daunting. I think there's some advantages on this whole new virtual reality, which is diversity and inclusivity. I think many of you have noticed that online dispute resolution means that those who are normally not able to travel for whichever reason now can just log in online. So it means that this world of international arbitration becomes accessible for many more. The same applies for online education, as we've seen. And in international arbitration, diversity is one of the main points on the agenda worldwide. The second could be that, and I say could be, that online dispute resolution, having virtual hearings, is cheaper. That's what everybody assumes, but we don't know yet if that is true. So with this, I'm going to move into the sort of caveats that I can identify as a non-IT, non-technology expert. One is, if you have virtual hearings, but not just the virtual hearings, also all the statements that would be submitted virtually. We've already lived in the world of e-discovery and electronic submissions for a long time, but now we're forced to really transition into a completely virtual world. My concerns are the following. One is security, and second, it's technology and the cost, and third, and Stefan already referred to it, it's the lack of personal interaction. So let's get into the topic of security. Anybody who is on this chat who thinks that nobody can hack into this right now is delusional. I've just discovered that 8-year-old children are hackers. So just to give a fun example, on a Thursday in times of pandemic, when everybody has COVID anxiety, we have a huge problem in our school, because in my son's year, and this is great too in the American system, there's apparently a hacker. So this hacker child has hacked into Google Meet and Google Chat and Google Classroom and Google Drive, and is sending vile messages to the teachers. And now there's a whole investigation going on who the 8-year-old hacker is. So we might have some child hacking into our meeting as we speak. Now for this webinar, that's not a problem. But if you have a UN session where state delegates want Chatham House rules to apply, this is a problem. We followed the news that Zoom is not secured, yet at this level, the UN level, law firms, everybody is relying on Zoom. So we wondered, at my former university in Miami, we have experts on cybersecurity. They've already circulated documents that show that Zoom is not secure. We have all sorts of other virtual platforms, which is Google Meet, Google Hangout, Blue Jeans, not secure. Now, there is one thing that you might now think of in the chat. I could give you 5 seconds and you can put it in the chat if you know what would be the secure platform that is more secure than Zoom. So I'm going to just wait for a couple of seconds to see if somebody can guess it in the chat. No, disappointing. It's blockchain. So some years ago, in Sao Paulo, actually, we launched blockchain ADR, which was called Samba. And the idea of this, this blockchain ADR is that institutions can use it, and the entire arbitration is online. So the parties, the arbitrators, the institution get a secure, unique key. With that key, you can log into this blockchain ledger. You can submit statements, procedural orders, and you can have the hearing and also post the award. The advantage is that it's online, so we don't have to travel. We save the papers, the cost of paper. And the argument was that you'll have all the original documents on this secure ledger. So you no longer have issues of, for example, for the New York Convention, do we need to authenticate, certify documents? So we thought blockchain is going to be the future. Then we discovered, and it's in the news, so it's nothing secretive, that even blockchain is not secure and you can hack into it. So the only thing we know is, unless you have a sort of FBI, CIA firewall, the online virtual world is open to anybody. And now we have a new generation of people, namely our children, who are all, by the time they graduate, professional hackers. So that's definitely my first concern. We had some meetings with engineers in Sao Paulo to understand blockchain and to understand all these sort of online submissions and happenings. And they said, we find it so fascinating that lawyers submit hard copy statements and awards, which is sent by a courier. They think that is very secure. And then from that, they jump to sharing things per email. And they said, if there's one thing that is absolutely not secure, is emails, and the step in between blockchain, everybody just forgot about it. So I think what we all know, we're just not educated enough. We need to learn a lot more how this works. And I think in this time, we'll find out. We'll find out what will leak. Another issue with respect to security is the administrator. So when we launched Samba, the blockchain ADR, Professor Martin Hunter immediately said, other than that he really didn't understand the chain of blocks in the virtual space, is, well, who is going to check on the administrator? So we're here, we have, I think, I would assume, an IT administrator who is helping us. At the UN sessions, there is an administrator who has access, but that's fine. However, if you have a blockchain setting, there is a company, an actual company behind it, that sets this up and that administers it. So will you have them sign NDAs? How will this work legally? So this is, again, who is going to police the administrator of all these virtual platforms? Now, what do I immediately think about is Facebook. Many of you will know that finally Mark Zuckerberg is getting punished, for which I'm very happy, and I'm happy that the world will know. It turns out all data was shared. Nobody knew. So I am not really comfortable with the idea that investor-state arbitrations not being ICSID, even disputes in international commercial arbitration, all of that is normally confidential, or there is the option that all of these things can be confidential. I am not sure if an online hearing will provide that guarantee, but I would say in the next couple of months or in the next year, we'll find out. So second, technology. So it's sort of a miracle that we're in Brazil, Germany, the Middle East, US, everybody is logged in. We have about, I think, 100 attendees. Nobody's internet dropped. Nobody's image has frozen, and we can all hear each other. This is a miracle. Last week we saw it took an hour for the administrator to figure out how to let people in. Technology, even though we're in 2020, we still have a long way to go. One thing that we shouldn't forget, and this is something that we discovered when we set up Young ICA 10 years ago, we had this worldwide mentoring program for everybody from every continent. They were linked to arbitrators in Europe. The one region where this did not work was Africa, because all the mentoring sessions took place through Skype, and in many African countries, the internet facilities aren't strong enough. And we see that now even worldwide. So for example, I'm in Bahrain, and we have issues here with the internet dropping because we only have one internet provider. So although you might think that online hearings will lead to more diversity, at the same time, it might not, unless we really make progress with technology worldwide. Another thing that many people, I think, don't know is that online is not necessarily cheaper. Now, I'm not an engineer, so however I'm going to explain this, it will probably be wrong. But when we talked about blockchain and having everything online and sort of parking all the statements and doing the hearing on this blockchain ledger, we thought, well, it's electronic, it will cost nothing, and it's so much cheaper than, for example, paper statements. These engineers explained to us that as compared to the cost of X number of pages and the cost of electricity and the internet and the bandwidth and the glass fiber network, etc., actually blockchain would be more expensive. So again, my point would be, we just need to do a lot more research and become more knowledgeable when it comes to online dispute resolution. Now, my last point is this, and again, Stefan said it as well, and we tap a little bit into due process. I read on Global Arbitration Review that the SIAC, the Singapore International Arbitration Center, has done a virtual hearing. There are those who say, anybody who's done a virtual hearing, give us your feedback. We want to know how this works. And so I think this was, so Singapore, Australian stakeholders from Europe, and they said it was fantastic. Everything went well. Well, right now. But let's see what happens when the award comes out, right? There will always be the losing party that then, like Stefan pointed out, might say, you know, something didn't work. There was a technology glitch, or God knows what have you. I think when it comes to online hearings, there is a lot we need to learn. This is the time to do it, but there is the nonverbal communication when you cross-examine witnesses, when the tribunal is sitting there and they are observing this nonverbal communication for all stakeholders is essential. There is the breakout rooms, there are other breaks, there is just the personal interaction. There are a lot of experts in the non-legal world who are writing about the damage that is being done because there is no personal interaction. And if it's already noticeable with a moot court, imagine how this will be for actual hearings. I think that if you don't have an actual in-person hearing, then why do you have a hearing? If we want to say we don't want to have a hearing in person for whichever reason, after this pandemic, it's too costly, it's not necessary, well, then you can say, well, let's not have a hearing. Let's just submit the oral arguments and have the arbitrators react. Let's just submit the witness statements and have the parties react and have the arbitrators react. My question then becomes, why do you have to do it online? Then just skipping the hearing would be an option as well. And I just saw some questions on the chat, which is, okay, you have, you know, in this situation, the arbitral tribunal will say, well, we have a commitment to have an efficient procedure to render the award timely. Otherwise, you know, there could be a due process violation. We want to have a virtual hearing. Let's assume one of the parties objects, says we just don't want to do it. And the tribunal goes ahead anyway. Rest assured there's going to be an annulment or a challenge, you know, resisting the enforcement afterwards. Let's have a scenario where everybody agrees. So the tribunal says, you know, this is okay, we can have a virtual hearing right now, the institution can facilitate it, both parties agree because we just want to get this over with. We don't know how long this is going to take. And like Stefan said, maybe something happened. Maybe nothing happened, but there is no evidence. So I could say right now, oh, I had no access to the chat, or I couldn't hear Stefan. and I can say it afterwards. The award comes out and the losing party will say, well, you know, this virtual hearing led to the fact that there was a due process violation. Obviously, then there's a good faith element, but we have to be mindful of this. And I think the only way to find out is see how things unfold right now, wait until the awards come out and see how parties react. So those are my concerns about technology. And then I also have a personal view, and I'm aware that we're not allowed to have any personal views, but I would say what applies to all of us right now, as much as we love, you know, bonding with our family members and doing homeschooling, I think all of us are creatures of international law, and the one thing that we want to do is see each other, and it's simply more fun. So I'm hoping that we're going to go back to some old normal, and that's my 50 cents.
I couldn't agree more. Stefan, final remarks?
No, I also agree. Yeah, the only question is if we cannot do it, and that was my prediction. Yeah, that I would say it may hold. Yeah, you have courts now going online. You have discussions, and I think arbitration. There is a duty for the tribunal to basically render efficient justice. And if one of the parties is really delaying it, and there are no real reasons, not to do it. Yeah, I'm not talking about a party sitting in Africa, but I'm talking about a party sitting, let's say, one in Germany, one in the UK, where I would say there is no major threat that the internet is not reliable. I completely agree with Marike concerning the much better possibility of checking the credibility of a witness, whatever, when you're in the room personally. But I think we're not living in a perfect world anymore. And you have to make certain concessions, which is difficult for a German to say. But I'm happy that at least once I'm a little bit more optimistic than someone else.
Well, I'm Dutch, so you know.
I truly think that the operative remark of everything that's being said is that we're still learning. I mean, the consequences are about to come, and we're going to be learning from the consequences, what are the problems and how to get over those problems. I think technology will be a major issue. I mean, it is already a major issue. Just like you said, Stefan, I'm teaching. Yesterday, I had a breakdown, and I'm not an IT technician. I had to go to the modem. I had to restart, reboot, blah, blah, blah. And I lost 15 minutes, and I'll never get back those 15 minutes. And there could be problems in an actual hearing. Those 15 minutes, one of the participants away, I totally agree. I mean, just this morning, I've been asked, and this is the situation that Stefan mentioned. Brazil has enacted a law prohibiting the export of medical equipment, just like many other countries. And just yesterday, Paraguay has issued a formal complaint because they're not taking into consideration the Mercosur laws. I mean, there are a number of laws of the common market, and Paraguay is a party of the common market, and one such impediment wouldn't be allowed under the Mercosur rules. And the question is, what's the applicable law? And my answer was pretty much what you guys just said. I mean, we still don't know. I mean, we don't know which law we apply. We don't know if by the time we decide a case, there will be a law, or there will be developments in the law, or just like Marike hinted, I mean, is there a treaty? Are we discussing a treaty? Not that I'm aware of, but I think the only paradigm we have, just like Stefan mentioned, I mean, we don't have anything comparable to what's going on in modern time, in our lifetime. The only thing that we have that resembles and pretty badly is a wartime crisis situation. And this is an ongoing war. I mean, the consequences are still to be heard, still to be felt. I think we only have solutions as time goes by, and as the institutions face the problems and offer solutions, whether the parties accept solutions. I think we should move to the questions. We have a couple of questions. Some of the questions I saw have already been answered by the panelists. Camila, you want to present Marike or Stefan with one of the questions we have?
Sure. So the first question we got, and I think this one was not addressed yet, is what is the boundary between a decision ex aequo et bono and the adaptation of the contract?
I assume that goes to me. That sounds a little bit like a moot court question, yeah, at a particular time. No, there is, in my view, there is a difference there. If you have to adapt the contract, if you have a clause there allowing a contract adaptation, you have certain trigger events, and you have to check whether the trigger events are fulfilled or not. Only then you have the power to adapt the contract. And sometimes you also have legal requirements or at least indications how the contract should be adapted. Ex aequo et bono, you're not bound by these legal restrictions. You can adapt the contract in a way you consider that to be ex aequo et bono. Extreme example would be a contract says you have to adapt the contract that it reflects or it is in favor of one of the parties. That's probably not ex aequo et bono, but I would be bound in a contract adaptation by that provision, while ex aequo et bono, I could do it slightly differently.
Excellent. We have a question to Marike. It's actually a question by Eduardo Grebler. Great question, Eduardo. He asks, pardon the analogy, but commercial diplomacy will not bring back some of the modified gunboat diplomacy, exactly what the ISDS system was designed to avoid?
Oh, no. So I'm really happy that he asked the question, because I realize that commercial diplomacy is a new thing that in the legal world is, we need to understand what it means, and I should have explained it a bit more. So yes, we started off with gunboat diplomacy. In some countries, we still see a bit of that, obviously. We have the court system, but with the whole issues of sovereignty, where we can always quote Fali Nariman, sovereignty is like billiard balls. They collide often, but seldom do they go in the same direction. And then we had arbitration as the solution. But now we see, especially in the ISDS field, that there is just building criticism, and we have a PR crisis of international arbitration. So what is now more popular? It's mediation, and it is what Martin Hunter calls third-party assisted amicable settlement. And that is the key, it's third party. So commercial diplomacy is done by people who were diplomats, so like former ambassadors who were in government, so former secretaries of state like Madeleine Albright, secretaries of commerce, former prime minister of other countries. So a whole network of people who used to be in diplomacy or in government, who are now with firms. So we have Cherie Blair, we have Madeleine Albright, we have Henry Kissinger, and there are many of these firms that we are not very aware of. And so now they are tailoring to clients, mostly investors, and they create a bridge between investors, between companies and countries, and they are the third-party facilitator. They do not belong to any government, and they can help kind of set up a communication line between governments and investors. They are the honest broker, and they can, in a sense, mediate disputes. So actually, we're getting further and further away from gunboat diplomacy. But what commercial diplomacy tailors to is when investors say, we don't want to have an arbitration. There are many general counsels even who are saying arbitration is not a strategy, it's the last resort. We want to have a solution that enables us to move forward. So that's what commercial diplomacy is.
Excellent. I think we are already 12 minutes past our time allotment. I don't know, as far as I understand, most of the questions have already been answered. So I don't know. Oh, we just got a question from Mauricio Go. Yeah. Good question. We know that we know nothing, especially on efficient virtual hearings on the merits. I think we're going to watch the demise of arbitration clauses being labeled as midnight clause. Drafters will be paying more attention to it. If you have 50 cents for the future, what do you guys think is the future for contract drafting and arbitration clause drafting?
I think arbitration clause should get much more attention. And after that experience, I would expect in every contract to have a contract adaptation clause that you don't have to rely on the provisions of the applicable law, and that is usually combined with the arbitration clause. But because in the end, someone has to decide what to do, whether to adapt or whether to basically terminate a contract. And if the parties cannot do it themselves, it's the arbitrator. And our experience, at least from the energy arbitration, is if there's a threat that someone else will decide, the parties are much more reasonable because they don't want anyone interfering with their long-term contracts.
I think that even Mauricio, it's so wonderful to see you at least online, but I can't see you, so virtual hugs and everything. But I think already arbitration clauses weren't really tailoring to all the issues and troubles that we see today. Already we had to make so many changes, even for obviously the enforceability of those clauses later on. One thing that I would want to add, regardless of how the world is going to evolve, is that these clauses need to be more holistic and need to be tiered so that you can enable parties to first try to find an amicable settlement. So I'm getting back to my mediation part. This is now the push of so many institutions. The push of UNCITRAL is that somehow there needs to be one part in that clause that also allows parties to mediate first.
Excellent.
Cláudio, I think we have 3 more questions. Luíza said we have time to address them. So if the speakers are willing to answer them, and if everyone has time, I think we can pose them. The second question is that during this crisis, we're seeing a lot of businesses that are in fact being affected by the pandemic, and others are just trying to be opportunistic and trying to take advantage of the situation. And given this, how should the tribunal shift between meritless claims and meritful claims?
Stefan, you want to go ahead first, or shall I?
Ladies first. Yeah.
Oh, thank you. So first of all, shame on those people. I think in the US we have seen the ambulance chasers and those who profit and have shame. But this is actually, let's compare this to something that we do know. So we see what we call guerrilla tactics, abuse of procedural mechanisms that are out there. We've seen so many reluctant state respondents who are being represented by certain lawyers who just find a way to delay proceedings, to obstruct. That already happens. And this is where arbitrators, right now, they cannot yet sanction, but we're seeing it more and more, actually, that arbitrators are trying to find way to sanction those, I would call them guerrilla tactics. And I think one thing when I look at this question, well, so those who are already really benefiting from the situation, would they have a claim? If there are those who act on I guess, bad faith, and they will file a claim, then really the arbitrators need to be competent and experienced enough to get enough evidence to comply with due process and to see that this is what happened, whether it's a claim without merit or whether it was guerrilla tactics, and just apply due process, but put a stop to it. So I would say if this happens, make sure you really appoint the right arbitrators.
That would have been my summary. In the end, you need someone who understands the business. It's not just someone who has been sitting as an arbitrator or it's your friend from the golf club. But someone who has some experience in particular business, understands, can read the balance sheets, whatever, and understands what is really going on. We will have abuses everywhere. So we have in Germany, the government is giving out generous support, and you're surprised how many people have tried to abuse that. Some have even set up a wrong web page that parties or small companies registered on their web page, and then they basically were submitting their claims and putting that money to their. You cannot prevent that. It's a fact of life. Just get the best arbitrator you can get.
I have to agree. It's not that simple. I mean, if you can determine that it's an opportunistic approach, then you have your solution. But things can get complicated. Right here in Brazil, we're facing the problem of Boeing and Embraer. It's a multi-million dollars operation that has just been denounced, and early this week they started arbitration and litigation. And I mean, it's been going on for 3 years. And the consequences of this coronavirus are unknown, but some of those consequences could be anticipated. Is this opportunistic or not? It has to be understood and studied on a case-by-case basis. And I have to agree. I mean, you have to have the panel to understand specifics, to rule on the specifics, and to apply the proper law and adapt whenever necessary and possible. I think we have a last question from Flavia, which is a very good question. I truly don't know the answer. I think we hinted, but there is a very blunt question. What happens when both parties do not agree with virtual hearings? Should the tribunal just stand still and wait for the time when physical hearings are possible to happen? What about the arbitral tribunal's duty to conduct the proceeding in an efficient manner?
Marike, or?
Well, so first, hello, Flavia. Great question. If I would be an arbitrator, I would not move forward. If both parties do not want a virtual hearing, they both agree, and somehow you get that in writing, I would say, okay, we'll just postpone. Maybe the tribunal could try to have a sort of, case management of some type of inter partes conference call to discuss it and understand why they do not want to move forward. And that obviously is very important. If this is one party or both parties are in a place where technology just isn't strong enough, then they have a valid argument. If they say, we just don't want to do virtual, we want to have that interpersonal, interaction or nonverbal communication, we are fine with postponing the entire arbitration, and that agreement is in writing. As a chair of a tribunal or a sole arbitrator, I would agree to postponement. But that is purely for due process, because if you push ahead with this, then you have an annulment on your hands probably.
I completely agree. If the parties agree, you're bound by their agreement. The only option you have as an arbitrator, if you don't want to be blocked for years by that arbitration, resign.
Yeah.
With that said, I think we're actually 20 minutes past our allotted time. I'll thank you, Luíza, on behalf of CCBC. I also thank our panelists, Marike and Stefan. Thank you, Camila, for being with us. And moreover, I thank you for over 110 people that dedicated their morning, well, if they're in Brazil, or afternoon, or whatever time it is, wherever they are. Thank you very much. And thank you, Eleonora, for opening up for the entire arbitral community this very, very good and with influence of Kansas CBC to discuss those very important issues. Thank you all. Thank you, Luíza. If you want to close the event on behalf of CBC, thank you very much.
Sure. Thank you so much, Claudio. Yes, I would just like to rephrase something that Stefan said. So we're not living in a perfect world anymore, and that is a fact. So I believe that the pandemic is not only accelerating digital transformation, but it's also compelling us to move forward and to leave behind these old habits, such as having hard copies, which have to be printed and sent by courier, and in-person hearings, like Marike said, the need to even have these hearings are all going to be considered. So let's just prepare and learn from this new time, new challenging scenario that we're facing. And thank you all for watching.
Thank you.
Thank you.
Thank you.
Thanks.